Good evening, everyone, and welcome. Merci d'être venus si nombreux. I'm delighted to see you all here tonight to talk about a wrongly neglected and terribly important topic, Canada's economic constitution. This is an issue which is not only urgent, but fundamental to the economic well-being of every Canadian. That is to say, the untapped economic potential embedded within our Constitution. And for those of you who don't know me, I'm Brian Crowley. I'm the founder and the managing director of the Macdonald-Laurier Institute. I'm glad to say we are going to celebrate in about 3 or 4 months our 15th birthday. So I remember when I was about to get the Institute going, and I went to consult a lot of people here in Ottawa, and I can't tell you how many people said, "Oh no, don't do that. We don't need a think tank in Ottawa. What a waste of time," and blah, 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 blah. And now I talk to those same people and say, well, haven't you always been here? Like, what would we do without you? Good question. So I'm pleased to say that from the very beginning of the Macdonald-Laurier Institute, the issue of the interplay between the Constitution and the economy was at the forefront of our minds. And one of our very first papers was a collaboration between Bob Knox, who was the former secretary to the group that created the first agreement on internal trade amongst the provinces, John Robson, and myself. We wrote this paper entitled Citizen of One, Citizen of the Whole, which is a quotation, I think, from George Brown, one of the founders of Confederation, when he was talking about what the founders' vision was for Canada. And it was part of what he said was, what we want is for a citizen of one, of any part of those previous British colonies, to be a citizen of a brand new whole. And we talked in this paper about what the Constitution was trying to tell us about the distribution of powers between the various parties, and what some of the greatest constitutional authorities in Canada had to say to us and others about the potential to use the powers of the Constitution in order to resolve this terrible problem of the barriers to trade between citizens. So this paper expanded especially on Peter Hogg's ideas about the validity and the scope of the trade and commerce power, as well as POG, to underpin a federally led removal of internal trade barriers. And no federal government has to date had the courage to tackle this, although history, morality, logic, and economics all tell us that only Ottawa is really in a position to sweep away the many barriers that still exist. And indeed, this was one of the principal reasons for the creation of a federal government in 1867. Yet since then, Ottawa has spent a great deal of time and effort playing in areas of provincial jurisdiction while neglecting one of the most important reasons for Ottawa's existence, that is to say, the creation of an open economic space within our country. And due in large part to poor policy, Canada has some very hard choices ahead of it. Our productivity growth is amongst the weakest in the OECD, with troubling projections of continued stagnation. And this slow growth isn't just an abstract concern for economists. It translates into real-world consequences: lower incomes for Canadians, billions in lost revenue for our federal and provincial governments, and that's money not available to pay for needed public services, including defense and national security, which we need so terribly badly. One of the most promising paths to reverse this decline is to remove these barriers to trade between the provinces. Studies from the Bank of Canada, the IMF, and others consistently show that eliminating these barriers would boost Canada's GDP by as much as 7%, a huge boost in national wealth and incomes. Yet while goods, services, labor, and capital flow freely across the European Union's member countries or across the 50 states of the United States, these movements are far more restricted within Canada. Regulatory mismatches, from licensing requirements to varying standards across the provinces, and other barriers create unnecessary costs, deter investment, and hinder economic growth. But addressing internal trade barriers is only part of the solution. Our Constitution also envisages robust protections for property rights, freedoms that over time have been eroded. Just think of recent events, such as the freezing of bank accounts during the pandemic, reminding us of the need to safeguard these rights against governmental overreach. Economic rights, including property rights, are not abstract. They are the foundation of our ability to innovate, to invest, and to prosper. And finally, we must recommit to federalism as a principle of governance. Our Constitution emphasizes subsidiarity, the idea that decisions should be made at the most local level capable of handling them effectively. And this approach fosters accountability, innovation, and prosperity. Yet federal intrusions into areas like healthcare, natural resources, housing, and others undermine this principle, stifling local solutions to local challenges, while in our view at MLI, Ottawa neglects responsibilities like internal trade, which only it can resolve. At this critical moment, we need a reset in our constitutional thinking, our federal-provincial relations, and legislative behavior across the country. We need a reset that strengthens property rights, that reduces barriers to interprovincial trade, and reaffirms the principles of federalism. And by doing so, we think at the Institute, we can unlock Canada's economic potential, attract investment, create jobs, and improve the lives of Canadians in every corner of this country. Now, I want to thank you all for being here to be part of this important conversation tonight, and I hope that you will go away inspired to speak to a larger audience about how we, together, Canadians, can advance a vision of this country that is both true to its founding principles and equips us to thrive in the 21st century. So with that, I am going to invite up to the podium our Deputy Director of Domestic Policy, Peter Copeland, who is going to introduce tonight's esteemed panelists and moderate the discussion that will follow. Please join me in welcoming Peter to the podium.
Hello, everyone. Is the mic good? Great. Thank you, Brian. Thank you for the history lesson and the comprehensive overview of this issue and why it remains important today. I'm Peter Copeland, Deputy Director of the Domestic Policy Program here at MLI, and thank you for joining us. It's my great pleasure to introduce my esteemed panelists here. First, we have Mark Mancini, farmost left. There's a lot, so keep track of them. Mark on the far left. Assistant Professor, Faculty of Law at Thompson Rivers University, former Director of the Runnymede Society of Canada, and a Senior Fellow at MLI. Second, Tim Sargent, to my immediate left, Director of Domestic Policy at MLI, Distinguished Fellow at the Center of International Governance and Innovation. Tim spent many years in the federal government as a deputy minister, as well as senior positions at the Privy Council office, and he is obviously also my colleague and a great boss. And third, Jack Mintz, Distinguished Fellow at the Macdonald-Laurier Institute, President's Fellow of the School of Public Policy at the University of Calgary, Senior Fellow at C.D. Howe, and a member of the Order of Canada. Two more things I could mention, too numerous to do. And last but certainly not least, Malcolm Lavoie, Alberta's Deputy Minister of Justice and a former Professor of Law at the University of Alberta. Malcolm is the main reason why we're here, thanks to his comprehensive and thought-provoking work, Trade and Commerce, Canada's Economic Constitution. So we've brought together a larger panel here because there are a few different aspects to address on this issue: legal, economic, and machinery of government. So to start, I'll turn it over, though, to Malcolm to give us an overview of the argument of the book before turning to Tim, Jack, and Mark for their opening remarks.
Thank you very much. And here it is, by the way, available on Amazon.ca. I could get about 8 cents out of every sale, so go ahead and order it. So when you write a book about Canadian constitutional law, you tend to temper your expectations for how it'll be received, or indeed whether it will be noticed at all. So needless to say, tonight's event would have exceeded my wild expectations regarding the reception of this book. I'm deeply grateful to all of you for being here and to MLI, of course, for hosting. So the book is about the economic constitution, by which I mean a series of commitments pertaining to economic relations that I argue are reflected in the Constitution Act 1867. Those commitments are secure property rights, local autonomy and subsidiarity, economic integration, and free trade. And I open the book with a discussion of the case of R.V. Como. And that's as good of a place as any to begin this evening. Como, as many of you may know, was the case of a retired New Brunswick steelworker who crossed a provincial border in order to buy some cheap beer in Quebec. Quite a lot of beer, incidentally, but by all accounts, it was for his own personal consumption. It was cheaper, yeah, fair enough. I shouldn't say cheap beer. By all accounts, for his personal consumption, but he did fill the trunk. But he was stocking up. Apparently, this was not uncommon in that part of New Brunswick. As some may recall, Mr. Como was charged by the police on his way back home. He was ticketed and his beer was confiscated. The offense, effectively, possession of out-of-province beer. Mr. Como argued that the provincial law he was charged under contravenes Section 121 of the Constitution Act 1867. That provision requires that goods from one province must be, quote, admitted free into another. Mr. Como's argument succeeded at trial, but was unsuccessful at the Supreme Court of Canada, which adopted an approach to Section 121 that leaves provincial legislatures with broad leeway to erect trade barriers as long as they are somehow connected to a valid provincial objective. We can say more about that later. I was counsel for an intervener in the Como case, and I think it's fair to say that the origins of this book can be traced to an exchange that took place during the hearing between Justice Malcolm Rowe and one of the other lawyers arguing the case. Justice Rowe stated, somewhat incredulously, I'll refrain from doing a Justice Rowe impression, but you can imagine, he stated, now you've said to us that essentially Section 121 is an anti-protectionist measure. You know, the Constitution Act 1867 wasn't a document that set out policies. It set out frameworks and competences. Why should we read Section 121 as incorporating a policy? In other words, Justice Rowe claimed that the Constitution is neutral on questions of economic policy. The moment I heard him say that, I knew he was wrong. And apparently I couldn't get over it because here I am 7 years later with a book to explain why he was wrong. I'm actually grateful to Justice Rowe for being so characteristically candid during the hearing because his statement reveals a common misconception about Canada's Constitution, namely that it is neutral on questions of economic policy. In fact, as I argue in the book, Canada's Constitution reflects a sophisticated vision of economic relations, one that is grounded in enduring principles of political economy. And the implications of recognizing that fact extend far beyond the proper approach to interpreting Section 121. So as I've mentioned, the book argues that the Constitution is committed to 4 key principles pertaining to the economy: secure property rights, local government autonomy, economic integration, and free internal trade. Of these principles, 2 have a decentralizing tendency, placing economic decision-making in the hands of property owners and provincial legislatures. The last 2 principles, by contrast, have a centralizing tendency, seeking to promote an integrated national economy with secure channels for interprovincial trade. And the Constitution reconciles these competing principles in impressively thoughtful ways. While Section 121 directly reflects the Constitution's commitment to free trade, other provisions of the Constitution achieve their purposes through more indirect means. 2 mechanisms are particularly important. The first is the separation of powers between the legislative, executive, and judicial branches of the state. In keeping with our British constitutional heritage, Canada's Constitution promotes secure property rights by limiting the power of the executive to infringe property rights in the absence of clear authorization from the legislature. Measures that tax or take property must be approved by the elected representatives of the people. Courts have traditionally reinforced these protections through a series of presumptions and common law rights, including the right to compensation for a taking of property unless a statute says otherwise. The second key mechanism is the exclusive nature of the division of powers between the federal parliament and provincial legislatures. Provinces are granted exclusive jurisdiction over most economic matters, allowing them to make decisions that reflect local circumstances, values, and priorities. However, at the same time as the Constitution vests broad economic jurisdiction in the provinces, the federal parliament also has exclusive jurisdiction over a series of discrete economic subjects that cannot effectively be addressed at a local level. Those subjects include, of course, interprovincial trade, transportation and communications, as well as matters pertaining to the infrastructure of economic exchange, like currency and banking. It matters that Parliament's jurisdiction over these subjects is exclusive. There's a positive aspect, the grant of authority to Parliament, and a negative aspect, which effectively says that provinces do not have jurisdiction over those subjects. It rules out overlapping provincial jurisdiction. The economic subjects under federal jurisdiction often give rise to impacts outside of a particular locality. In the absence of constitutional restrictions, provinces would be tempted to enact policies favoring local interests at the expense of outsiders, including by erecting trade barriers. This is a classic collective action problem. If all provinces erected trade barriers, they would all be worse off. The Constitution responds to this inherent problem of federalism by limiting provinces' ability to affect economic interests outside the province. Similarly, the Constitution protects the local autonomy of the provinces by providing that provincial jurisdiction over local matters is also exclusive. Federal legislation that overlaps with areas of provincial jurisdiction has the potential to undermine provincial autonomy. And so, Parliament is barred from legislating in areas of exclusive provincial jurisdiction, including property and civil rights and natural resources. The text of the Constitution, if you read it, is clear to the point of redundancy in stating that federal and provincial powers are meant to be mutually exclusive. Unfortunately, courts and governments in recent years have moved away from the Constitution's model of exclusive heads of power, adopting instead a flexible approach to federalism in which federal and provincial laws overlap considerably. The move towards flexible federalism has had unfortunate consequences, both for provincial autonomy and for the Constitution's commitment to economic integration and free internal trade. There's much more to be said, including how the economic vision can be restored in the present day, but I'll leave it there for now. Very much looking forward to the discussion. Thank you very much.
Thank you. Thank you, Malcolm. Tim?
Okay, evening everybody. Definitely a pleasure to be here. So I'm sharing the stage with a distinguished economist and two distinguished lawyers. So I'm going to say a few words about this from a perspective where I can actually bring some additional value, which is that of a former government official who was involved in policy making for quite a long time. And so I want to think about this from a political economy and a public administration perspective. I should start by saying, there's no doubt in my mind that maintaining property rights, having a clear division of responsibilities between different levels of government, and ensuring free movement of goods and services are key for maintaining a strong economy. And deviating from these principles imposes very significant costs on the Canadian economy. So what happens if you don't respect those principles? Well, firstly, you lose accountability. Voters need to know whom to blame when things aren't working. And sometimes the right people to blame are the people themselves. Government can't be responsible for everything, and when you take away rights, you also take away responsibilities, and that's something we should think hard about. And I agree with Malcolm, the constructs of cooperative federalism and flexible federalism, these have been sort of accepted, not without question, but seem to be viewed as fundamental tenets, but they really blur accountability in the political system. So healthcare is a good example. The federal intrusion into this area has made the government responsible for everything that goes wrong in that sector. And it's made it easy for provincial premiers to blame all of these problems on the federal government, which means that instead of undertaking the hard work of reform, premiers prefer to pressure the federal government for more money, which is about the only thing the provincial premiers can agree on, even though that's not the fundamental problem with the system. The problem with the system is not that there isn't enough money. There are entrenched interest groups. There are other problems that need to be addressed. We're seeing a similar dynamic emerging in housing, where the federal government seeking to intervene in an area where responsibility for problems with housing supply, I mean, it's already blurred between provinces and municipalities whom voters should blame, and now the federal government also wants to get involved in this particular party. Second, and related to that, you also reduce your ability to stand up to special interests. Many, if not most, of the interprovincial trade barriers that we have, such as provincial licensing requirements for professions, are the result of lobby groups seeking a special advantage for themselves that will have negative impacts for the population as a whole. And because these benefits pertain to a specific group in a specific province, whereas the costs are felt across all of Canada, provinces are often not very good at saying no to these lobby groups. And so that's why maintaining free trade in Canada is actually done best at the federal level. It's actually done best farthest away from these groups, because the federal government will just be more resistant to these local special interests, which is not to say that they will be entirely resistant to them, as we see with supply management. Third, and it's not always appreciated, is you lose competence when you deviate from these principles. The federal government doesn't know that much about healthcare. It really doesn't, because it doesn't deliver it. So it's not faced with the day-to-day problems of implementation. It doesn't understand the structure, and because it's not involved with it day-to-day. Similarly with housing or vocational training or local infrastructure. Deputy ministers, speaking from experience, are generally promoted on their ability to provide policy advice, not whether they have successfully delivered services to Canadians. The federal government's just further away from the population. Now, for things like national defense or negotiating international trade agreements, that doesn't matter. I mean, in fact, there can be some advantages to that. But for other areas, it matters a lot. Federal government's just not, just does not have the experience and the competence to get involved in these issues of local service delivery. And fourthly, you get a lot of expensive duplication. Because Ottawa, for example, has decided to become deeply involved in all aspects of environmental regulation, we have now both the provinces and the federal government involved in deciding on major resource projects, even if they have only local or provincial impacts. So this duplication, it adds to both the approval time and to the uncertainty. You're just creating more legal avenues for people to hold up a project. And this is ultimately leading to investment dollars going elsewhere. So just to conclude, I'd say that both from an economic perspective, but also from a good government perspective, it's really imperative that Canada return to the clear principles that our founders intended.
Well, thank you very much. This is a pleasure, actually, to hear Reid's, Malcolm's points of view. In fact, I heard him speak a number of years ago in Calgary on the whole issue of how to deal with constitutional problems around pipelines, which, of course, is a very significant problem in Alberta, particularly with respect to TMS. Oh, it's not working?
Can you hear me now? Okay. So first of all, let me say that I agree very much with the opening comments made by Brian about the need to think about Canada as a whole and not thinking about we're in a post-nationalist state, whatever that means, where somehow we just do whatever we want to do as different parts of the country. I think we do need to have some principles that we accept. And I do appreciate Malcolm's book, where he tries to lay out an economic constitution, which deals with property rights and federal provincial assignment of powers, as well as trade. So I'm going to say a few words about each of them in terms of some comments that I'd like to say about some of the practical issues that maybe one has to think about. But generally, in terms of what Malcolm is suggesting, I wholeheartedly agree with the points that he makes. So first of all, on property rights, I think we have to remember that one of the worst things for investors when they're making decisions is to think that in the future somebody might come along and confiscate their property and not give you value for it. And I've sat enough on corporate boards where we're trying to determine investment decisions, and we know the terminal value is very important. And if that becomes very uncertain in investment, then you might decide that maybe that's not a place or a time you would like to invest. And I'm sure that's exactly how the energy industry now feels in Mexico, where there's a government there that's talking about potential confiscation of capital there. So I think the idea of protecting property rights is a good one from the point of view of having certainty for investors, but also the importance of generating the kind of economic conditions that one wants to get with a world in which investment can at least have some certainty, even with all the risks that are associated with making investments at any particular time. However, when you do get into points where confiscation is needed to, let's say, build a railway or a dam or some other important infrastructure that is clearly important to society, obviously it's important to give compensation according to fair market value. But that's an issue in itself. Again, I've sat on enough boards and gone through finance theory myself over the years to know that there's a lot of guesswork associated with what a fair value is if you don't have a market value already to use as a way of comparing different properties. And that happens a lot in the kind of decisions that have to be made. And the question is how you determine that fair market value is not easy. Of course, you can line up 20 economists and finance theorists or financial specialists to develop their estimate of that amount. But I can tell you the only time you ever really know the fair market value is when some exchange actually takes place between people. And that is a difficulty that's always going to be there. Another issue, of course, is how do you deal with holdouts? And this is when you are, let's say, undertaking a major investment and you have to buy out property of different people. Of course, you have certain people that are pretty smart. They know how to game the system. They'll be the last ones to sell, and they'll say, well, if you really want my property, my house is worth $1 billion, and that's how much I expect to get. That's my fair market value, which, of course, makes absolutely no sense. It wouldn't really happen. But those situations are really quite serious. And the question is, how do you have some sort of rule where somebody at the end has to sell, even if they don't want to? And we've done that in corporate law, and I'm a little nervous sitting between two lawyers talking about corporate law. But as I remember, for example, if you have a reorganization taking place or a merger and acquisition, you have to have 90% of the shareholders to agree to it. If I think that's the correct number, maybe I have that wrong. But anyway, but the main point is there is a threshold, and the other 10% have to go along. Otherwise, you could end up making it very difficult to have any sort of change that's possible. And so I think that's something that has to be dealt with. But there is one very tricky situation, and I'm going to probably leave Malcolm, who has much more expertise in this, to talk about it, or some people here in the room. And that is, what do you do when you need to get Indigenous support for important projects, which is really critical to Canada, given we are a resource-based economy. And I think the Trans Mountain Pipeline is a perfect example. In fact, I heard Malcolm talk about that years ago. But when you have, let's say, roughly 120 First Nations that have to agree along the way to the building of it, you could get a situation where 90 or 100 of the First Nations have made agreements with Trans Mountain to go ahead, but then there are some holdouts that say they're opposed to it. And they're not necessarily holding out because they want more money. That wasn't the reason. They're holding out for whatever things that they believe in. But there is a treaty that is between Canada and First Nations in various things. And I know BC is a special case, which I'll leave to others to discuss. But the question is, can you really have some sort of rule, let's say, as long as, let's say, 90% of First Nations agree with making the change and the other 10% have to go along with it. I don't know if that's something that can work or not. I'll leave that to the lawyers to discuss. Federalism is another important issue, and I half a century ago, as a graduate student, I used to read a lot about federalism, and I remember Donald Smiley's work. Donald Smiley was at Queen's University, and he talked about watertight federalism, where each each level of government should have their own particular powers and not interfere with the others, and try to keep these things separate. But as we know, the world is a little bit more complicated than that. I do think it is valuable to think about the allocation of economic powers in a federal state. There are some powers that are very important to put at the federal level, such as banking as a good example, because of the nature of the business that operates across the country. And in telecommunications, we've had actually fairly strong federal presence, and as a result, we've had more, let's say, openness of regulations across jurisdictions than what you find in something like the power industry, which is provincial. And of course, the way that that's been protected by provinces, that most of the provinces, except for Alberta, have a dominant monopoly that's a state-owned enterprise running the power industry. So you, again, have all sorts of interference in that case. And so there's a number of issues that have to be dealt with. Again, in thinking about this, I actually happen to like the watertight concept, partly because I like political accountability, as Tim said, but also I think it can be more efficient in some cases. But regardless, there's always going to be problems that are going to occur. First of all, there's issues where you have conflicting powers. As we saw in the case of the carbon tax, it was the peace, order, and good government power that ended up overriding provincial rights with respect to resource development. We're seeing a very different view with respect to regulations that apply to electricity, et cetera. But I think we have to remember that the federal government may have powers over international trade that can sometimes override provincial powers, but also you can have peace, order, and good government that can also override provincial powers too. But again, I think maybe we need to think a little bit more about some limitation to those things, to the extent that the provincial powers should be observed. And in fact, where there is a conflict, I think that's where Canada works best, is federal and provincial governments working through how to deal with those conflicting powers. Another issue, I think, is spending power. Federal government has more ability to raise revenue than the provinces. And so historically, we've had conditional grant programs and unconditional grant programs and block grants, et cetera, that the federal government has given to the provinces, some of it for equalization of their different fiscal capacities. However, the spending power has allowed the federal government to override provincial jurisdiction. And sometimes I would like to see, and I have a question for Malcolm on this, I wouldn't mind seeing maybe a prohibition of spending power except under certain conditions. Because I think it's a real serious issue that we are getting right now, federal government that is intruding in childcare, pharmacare, dental care, although dental care they're using their own tax powers and spending powers for that, and of course health care, which I don't know, when you think about it, why should the federal government even have the Canada Health Act? It's one thing if the provinces want to have their own limitations, but why is it that the federal government is insisting on this particular way of running the health system? Why not just let the provinces do what's best from their own perspectives? Let me finally finish with a quick word on trade. And I won't spend long, because I don't want to go, I've probably gone over time. But I just want to say, I totally agree, of course, we should try to reduce internal trade barriers as much as possible. And after reading Ray Minucha's book, Karen Russell and I had the pleasure of dealing with that book as we were both jurists on the Donner Prize for Best Book in Public Policy. That was a terrific book that was written, but it tells you how slow that area is for development. What worries me is that even though I'm a free trader, and in fact you may have seen a recent article where I talked about that, that's not where the world is these days. There's no question economists make a good case that free trade is a good thing. There's significant economic efficiency associated with it, and you can reduce costs, et cetera, et cetera. But of course, underlying all the time in an economic model is that if you have winners and losers, the good thing about free trade is that one can create so much income that you can compensate the losers that might be affected by the policy. The problem that economists have had is that they've never figured out how to compensate the losers. And that is a big issue. And what we've seen both in the United States and in Canada, as well as other countries, is that free trade has lost its shine. Why? Because we've seen what happened when the heartland of various countries have been hauled out as we had this huge shift in the world economy when China came on stream after 2000. And we can go into the history about managed trade and all that sort of thing, but we have to think about internal trade very much in that perspective in Canada, that there's always going to be special interests in every province that will want to protect themselves, but also governments who are very sensitive to their populations want to do that as well. That's not to minimize the need for moving towards a better economic union, as the Europeans have done, and we should certainly do that. But I think we have to remember that, sadly, the idea of internal trade, free trade, has been, I would even argue, corrupted by mercantilism that has now come back, that we haven't seen for quite a long time, especially since the Second World War, when countries around the world adopted the GATT system, and later the World Trade Organization as a way of encouraging free trade amongst countries. And we've been slow to do it in Canada within our own country, but I think it's an issue that needs to be dealt with. If we can strengthen Section 121 in the Constitution, I would all be in favor of that. And Malcolm, by the way, I was on the Alberta beer case as an expert witness, which the NDP government tried to put in a tariff basically on beer coming into Alberta, imported beer. But it's one case that actually won out on for free trade, which was a good thing. And even today, I don't know why I can't get online, sitting, let's say, in Toronto, and I can't order great bottles of scotch from the Kensington Wine Market in Calgary, instead of having to deal with this old LCBO in Ontario that has got one of the most boring lists of alcohol I've ever seen. So I'll leave that as my final comment.
All right. Well, I hope my mic's working. I think it is. Yeah, good. Well, I'm glad to be here. I'm especially glad to be here because I'm on the stage with an economist. And, I'm a graduate of the University of Chicago Law School. So anytime I can masquerade as an economist, I will do that. I will do that. But today, I'll try to stick to my knitting today. And what I want to go back to from a legal perspective is what Malcolm brought up. I want to start with Justice Rowe's comment in the Como case. There's a sympathetic way to look at what Justice Rowe was saying. And the sympathetic way is this. Look, we have a text of a constitution here, and the text is what the text says. And we can understand why somebody like Justice Rowe might say that. The Supreme Court is inundated day in and day out with litigants coming before them, asking them to stretch, compress, be creative, like Plato with the text of the Constitution. And so one imagines that Justice Rowe, and he's a good common law judge, I would think, one imagines that faced with this argument in the beer case, he says, we have to hold a line somewhere here. We have to say that the text of the Constitution does what it says. And so I'm sympathetic to that position, and I'm sympathetic to the motivations for it. But I think, even though I am a textualist, I do think that the story is a bit more complicated than that. And there's two things I want to point out about Malcolm's view of the economic constitution that I think really does ring true for us sitting here in 2024 about what our constitution does. And it's not just words on a paper. There are reasons why we put the words on the paper in the order we did, in the way that we did. The first thing to say, and this is important, is that structure is destiny. And that's a Justice Scalia quote. Structure is destiny. What does that mean? There's a method to dividing power between the federal government and the provinces. We deny the federal government the widespread power to do whatever it wishes, and we deny the provinces that same power. And we hope by doing that there's going to be a productive contestation between the two levels of government, but that liberty is going to be protected because there's going to be certain no-go zones for both the federal government and the provincial government. There's a logic to doing this that is liberty enhancing. So just that alone, just that exclusive division of powers alone is worth something. But let me go a step further. The lawyers, the framers, the early judges of the Supreme Court that were asked to interpret the Constitution Act 1867 they didn't come out of nowhere. They came from a certain common law intellectual heritage that we've somewhat lost now. And we've lost it because of something that an author in the 80s, and I'll say the same thing now, what he called charteritis. Okay? The sickness that we get from bringing in an entrenched Charter of Rights in 1982 and believing that that charter represents year zero. That's our rights. It's contained in that document. And Pierre Trudeau came down in benevolence and gave that to us. In reality, the Charter is a meaningful, important addition to our legal heritage, but it's not the only piece of it. In the 1800s and the 1900s, common law lawyers were very used to speaking about Parliament as a protector of fundamental rights and fundamental liberties. We imbued Parliament with these certain characteristics that was going to be where our rights and freedoms were protected. And so 1910, one of my favorite judges, Chief Justice Lyman Duff, Supreme Court of Canada, said this, and this is a big statement, but it shows the relevance of these sorts of economic liberties even in the present day. He says, "No canon of construction, I think, is more important than that which declares that a legislature should not be presumed to have taken away private rights without compensation." Now, this was just part and parcel of being a common lawyer. This was part and parcel of the heritage that common law lawyers had, common law judges had, and there was no conflict between the written text of the Constitution Act 1867 and these sorts of principles, because Parliament was seen as being a defender of the principles. The Constitution was enacted against the backdrop of these individual liberties. Now, we might say, if that's the case, how do we demonstrate that the text of the Constitution should be interpreted according to these liberties? And that's the work that Malcolm does in the book. He goes into deep textual analysis of what the Constitution Act 1867 does. He looks at the Confederation debates. He brings us forward to that common law heritage and helps us to rediscover it. And that, I think, is going to be a very big part of where we go legally with understanding the Constitution in the 21st century. We can't just think that 1982 tells the story because, big omission, 1982 doesn't consider property rights. Instead, we look to the common law for these things. And while we're doing this, we're going to have to keep two things in our head at once. We're going to have to keep, on one side, the idea that the text of the Constitution means something. It isn't just Plato to be reenacted by judges as times change. But that at the time that in 1867, when that text was enacted, there were important background principles of law that the text assumes. One of those is that structure is destiny. Another is that there are liberties that we're not going to be as eager to conclude that Parliament took away. And understanding this is going to take some of the deep work that Malcolm does in the book, and it's going to take a much more interested judiciary in these sorts of questions. One piece just to conclude on this, law is not everything here. Law is not everything here. By that I mean, here's just one thing. In the last 9 years, the public service has grown by 40%, the federal public service. Now, how does that relate to this? Well, we're talking about how the federal government is expanding its claws into provincial jurisdiction. It's doing so on the back of this enhanced public service, new hires brought in to try to increase government capacity. The solution to much of these things is going to be political. But the backdrop that we need for the political solution to happen is legal. We need to have a good understanding of the framework of our Constitution and the fundamental principles it enacts. And that's what I think Malcolm's book, in this realm of federalism and the division of powers, really helps us struggle towards. And so I'm looking forward to chatting about that more tonight.
Very good. Thank you to each of you. I think we have a great sense now of what's at stake, the issues in play. I want definitely to get into the solutions. But before we do so, let's spend a bit of time on property rights, federalism, and then barriers to trade. So first, a question to Mark and Malcolm. To what extent is the property rights solution, does it require a constitutional amendment or a reinterpretation, judicial reinterpretation of the Constitution? And then beyond that, what role should federal and provincial legislators play in safeguarding property rights within their respective jurisdictions? How can they ensure that property rights are respected without limiting the government's ability to enact policies for the common good?
Well, thank you very much, and thank you all for those very thoughtful comments. As you were all getting into these interesting, sensitive issues of contemporary importance, I was reminded of something that I should have said at the outset, which is that everything I'm saying tonight is speaking for myself only. If you don't like something I say, please bring it up with me rather than my bosses in the government of Alberta. On the property rights question, yeah, so the Charter is an outlier. In terms of civil rights documents all around the world in not providing express protection for property rights. But as Mark astutely pointed out, the Charter isn't the be-all and end-all of rights protection. We have a much older tradition in Canada of rights under parliamentary supremacy, of rights that are protected through the common law, subject to potential override by legislatures. And in a system like that, there's a very important role for legislators in having that position of making the final determination of when rights need to yield to the public good. So we're really used, in Canada, post-Charter, we're really used to this paradigm of rights mean something that's interpreted by judges. The older tradition of common law rights, in fact, puts the legislature in a role of making those final determinations as to when an override is justified. And you know, property rights, like other rights, are not absolute. And there needs to be a judgment sometimes that they must yield. Our system of government gives that role to Parliament and provincial legislatures. In terms of what we can do within this sort of paradigm to strengthen property rights, though, which have been in various ways eroded over time, there's a few things that can be done. So first of all, we should remind courts of the importance of these rights. We have a recent judicial decision in a case called Annapolis, authored by Justices Cote and Brown, that reinforced these common law protections and this idea that compensation rights exist unless the legislature says otherwise. There are legislative steps, though, that can be taken as well, assuming for the time being that a broad constitutional amendment entrenching property rights is not something that's going to be plausible. You can still have legislated protections, and so there's a model for this. Alberta recently amended the Alberta Bill of Rights to provide stronger protections for property rights, essentially reinforcing what the Supreme Court of Canada said, and going a little bit further than what the Supreme Court of Canada said in Annapolis, saying that any time a government takes property, whether it takes title or whether it simply regulates away the uses of property, compensation should be paid. And so that's now part of the Alberta Bill of Rights. A similar amendment could be placed in, say, the Canadian Bill of Rights or in other provincial jurisdictions, which would send that message. It would be a reassertion of the importance of property rights coming from the legislature that would then go to the courts. So that would be one way in which these rights could be enhanced today.
Yeah. Let me just say one thing about constitutional amendment. I mean, constitutions are supposed to be difficult to change by design. And that is especially true when we're talking about an entrenched charter, which means that we've given judges the power to say when the legislatures go wrong. We obviously don't want those rules of the game to be changing with every year. But I do think it is a sign of our sclerotic political culture that the very idea of discussing a constitutional amendment is flat out off the table. Now, we can talk about, maybe that's the amending formula. Amending formula is very, very difficult to achieve consensus on in Canada. But it's that the very fact that we can't even imagine a constitutional amendment ever being brought forward, even one, say, to protect property rights, I think is an indictment of our political culture. And that connects, I think, to the question about property rights. I think part of the problem is increasing, part of the challenge is increasing in the public consciousness the importance of property rights and why we have them and why we should have them and why they should exist. it isn't just that we're not Americans and Americans talk about property rights, and in our political culture that doesn't exist. Again, this is a deep part of our common law heritage. The first step to getting legislatures to move on these sorts of questions is to increase public consciousness and knowledge of them. And that happens in the law schools, that happens in legal education, where we need to do a much better job of teaching of this common law heritage. But I think the politicians can move this forward as well, as Malcolm pointed out. And that's going to be the challenge, is incentivizing politicians to see this as an important piece of the puzzle for our own economic development, but also as an important part of our legal culture and our legal heritage that has been forgotten because of the omission of those rights in the Charter.
Okay, very good. Let's talk now about the economic consequences of better recognition of property rights. Tim, what effect would this have, particularly in areas like resource management, housing, business development? What are the economic benefits and risks? Because it shifts the onus and the incentives and everything when doing so. If we're to provide more protections for property.
Sure. I mean, what you're doing with property rights is you're actually giving individual citizens a vote, in a sense. You actually, instead of a government simply thinking about, well, I've got this stakeholder group and that stakeholder group and those provinces, and so what politicians do is they make a calculus in their minds about who they want to offend least, whose support they're seeking, and then they move forward on this basis. And a good example would be a world that I know well, which is in fisheries. And ministers making these decisions, I mean, they're thinking about this fishes from this province, fishes from that province. When it's crossing a boundary, maybe they're thinking about other stakeholder groups, maybe thinking about Indigenous people. But often they're not going to think necessarily about individuals unless those individuals are part of some sort of association that can bring political pressure to bear. So when you actually have to sit and worry about property rights, you actually come back to the individuals. You're actually empowering individuals. You're making it easier for them to use the legal system to defend their interests. Is that a good thing or a bad thing? I mean, you can run into the problems that Jack had talked about, where you have somebody who's impeding the moving forward of the common good. But then I go back to another thing Jack talked about is if in economist parlance, this is a Pareto move, it should be able to, you're making everybody better off without making anybody worse off. If this is really going to make society better off, then you ought to be able to compensate. And I think that's what the property rights can do, is it forces government to think about, well, we have some individuals here who are affected. How are we going to compensate those individuals? Again, you can't necessarily write a blank check, but at least you have to take them into account. And I think that has ultimately a beneficial impact on the political system. It forces you to think about these individuals as opposed to just interest groups that shout the loudest.
Very good. Another economic question now, but shifting on to federalism and subsidiarity. This one's for you, Jack. The economic vision of the Constitution lays out the case for jurisdictional exclusivity, and that obviously could benefit provincial economies. So in your view, what specific economic areas or industries might benefit most from such a shift in constitutional interpretation, and how can provinces leverage the newly protected powers to drive regional economic growth? And as you were talking about some of the winners and losers, so maybe you could add who might be some of the losers in such a scenario.
Well, I think, first of all, we have to recognize what the value of federalism is. And I think in my, I could be corrected on this, but as my reading of what this 1867 Constitution was, well, really we want a unitary state, but we're going to try to accommodate these things called provinces, partly because of the historical divisions between Quebec and Ontario at that point, and the need to satisfy Quebec, and so therefore education became a power of the provinces. And unlike United States, which you can have a federal role in education, that's not something that has been done in Canada. In fact, the only role the federal government has, of course, is funding research, which is a different thing. So in terms of your question, I would say that we have to recognize that federalism is a good thing in a country like us because we have a very dispersed population with different historical backgrounds and cultural backgrounds. In fact, there's been some excellent books written on the evolution of North America and how it evolved. And we have to recognize that people do have these different backgrounds. And it's very easy for Canada to break up into several countries if we didn't properly handle this tension, I think, between trying to have a central government that brings together certain important externalities amongst the regions and allowing at the same time the regions and the provinces to be able to develop their own industries. So without going too deeply into some of the comments that Malcolm had, I think that giving certainly, provinces have been able to handle their own corporate income tax. They're able to do a number of things to develop their policies. Where the big issues have come up, of course, has been where the federal government wants to get involved with industrial development in particular parts of Canada as well, like regional development programs. Frankly, I don't think there should be regional development programs in Canada. That was something that started up in the 1970s, particularly. And because I don't think the federal government should be doing that. I think the provinces should be doing that as a power. And so the question is whether you can put limits on that or not. I'm not sure. I'd certainly be interested to hear what Malcolm has to say.
Okay.
Just briefly on something that you said there, Jack, about the sort of purposes in 1867. There were certain English-Canadian historians who wanted to tell the story in the middle of the 20th century that Canada was really intended to be a unitary state that was really meant to be quite centralized, and they relied upon the purposes or some of the statements of John A. Macdonald in particular to make that case. But since then, there's been kind of a realization that that goes much too far. That if you go back to 1867, a bargain really wasn't possible without substantial jurisdiction at the provincial level, particularly with respect to Quebec, as you noted. And the Constitution isn't what any particular founder, even John A. Macdonald, thinks it ought to be. It's what it says in the text, and the text gives exclusive jurisdiction over property and civil rights to the provinces, which is a constitutional term of art of great breadth. It was understood at the time to encompass the full range of private legal relations, including economic relations. Provincial natural resource power should be mentioned as well. And so I make the case that there is this broad presumptive ability of provinces to regulate economic matters, and then there are these effectively exceptions where we say, you know what, on these matters, you're affecting people outside of your jurisdiction, or you're unlikely to be effective at the local level. So we'll make an exception for banking, currency, interprovincial trade. But the presumption, and that's where I get the principle of subsidiarity from, is local. And to the point of, where could this be of benefit? Many areas. Natural resources is one thing where you have provinces with their own perspectives and their own knowledge of circumstances on the ground. Healthcare, where we could use a lot more policy experimentation in Canada, and as has been mentioned, that's precluded to some degree by an aggressive use of the federal spending power through the Canada Health Act.
Very good. Okay. Another argument in your book, Malcolm, staying on the topic of local decision making, is that it should be extended or could be extended to First Nations. How could the recognition and protection of Indigenous property rights be incorporated into Canadian constitutional law without disrupting the broader economic interests of the nation? And since you've made the argument, Malcolm, I'll turn to you second for comments, but to you first, Mark, if you don't mind for that. Yeah.
Well, I mean, this is one of the real pressing challenges of modern Canadian federalism, and it's something that we have some experience with. When in 1992, the Charlottetown Accord was brought forward, and the Charlottetown Accord envisioned Indigenous orders of government operating as a third order of government. And this would have been a constitutional amendment. Of course, the Charlottetown Accord failed via referendum. Now, the wisdom of the Charlottetown Accord was that behind in the structure of Canadian federalism, even in the doctrines we use to interpret the Constitution, there is this pluralism built in. And there's pluralism built in because of the Quebec question. There's pluralism built in now because of Western Canadian alienation. There's an understanding that local decision-making by those closest to the people that are going to be affected by the decisions can fit into our federal structure. The failure of the Charlottetown Accord meant that if that was going to happen now, the delegation to Indigenous groups would have to be via normal legislation and not via the Constitution. So that makes it a lot harder for us to incorporate this question into how we talk about the federal structure of Canada. It means that the setup is much more patchwork, depends on the powers delegated by the legislature to particular Indigenous groups in particular cases. I think what Malcolm's book, at least from the legal perspective, helps us to understand is it helps us to, again, deepen some of the reasons why we have the federal structure in the first place and how it can grow to accommodate distinctive Indigenous communities. We have the tools in place. We have the idea that there is exclusive jurisdiction in local governments. We know how that works. We have the tools available to deal with the problem, but it's a question of political will and also a question of just bringing to the fore these ideas that are going to help us sort that out. And I think that's one of the contributions of the book.
Anything brief to add on that, Malcolm?
Just jump in quickly. I make the point in the book that there is great wisdom in terms of the political economy, ideas that inform the Constitution Act 1867. But at the same time, there's no doubt that the late 19th century was a low point for Crown Indigenous relations, and that Indigenous nations were largely overlooked by this framework. Nevertheless, I think that there are some ideas we can draw out of this as we work as a country to more properly recognize Indigenous governance and decision making, both in terms of Indigenous property rights and in terms of Indigenous jurisdiction. The insight that local decision making is vitally important applies to Indigenous nations just as it applies to provinces and to property owners. In terms of how do you reconcile Indigenous property interests with the broader economy, I think we've lost sight of the importance of clearly defined property rights that can actually be used meaningfully for economic development. In some of the Supreme Court of Canada jurisprudence, we have Indigenous property interests that are sort of distinctive and poorly defined, that have unique restrictions on the use that the property can be put to, or as well ill-defined restrictions on transfer. I think property rights, strong property rights, can enhance economic development, including property rights held by Indigenous communities, as long as you have those attributes of clearly defined rights that are actually useful for engaging in economic development. And similarly, with respect to jurisdiction, a clear definition of the jurisdiction of Indigenous governments is important, and as well as some of the subjects of that jurisdiction. How do we incorporate this Indigenous order of government into the Canadian Constitution? Well, there's some wisdom, I think, in the division of powers federally. There are some types of subjects that are best dealt with at the local level, and there are other subjects, like, for example, interjurisdictional pipelines, transmission lines, et cetera, that are best dealt with, I think, at the federal level. And doctrines like the duty to consult, while important, I think, can be developed in ways that try to avoid a situation where you have holdouts that can shut down projects that are of broader utility and value.
Okay, very good. One question on freedom of trade, then I want to get your thoughts on the most practical solutions to realize the vision before we open it up to the audience, so start thinking of your questions. So for Tim and Jack, freedom of trade, what are some examples of federal legislation or regulatory measures that could help standardize rules for interprovincial commerce, such as trucking regulations or labor mobility? How can the federal government ensure that these initiatives respect provincial autonomy while promoting economic integration?
I can kick off. It's important to recognize that the federal government can't force the issue here. It can use its convening power, it can use its spending power, but of course it's tied by the Constitution, and in many ways that might be a good thing. But of course, as being referred to, that spending power is not insignificant. So you've seen a number of proposals that would say, look, if you liberalize interprovincial trade in Canada, the economy will benefit, tax revenues will go up, and they'll go up not just for the provinces, but they'll also go up for the federal government. So you could imagine a world in which the federal government says, well, I am willing to share that increase in tax revenues that would come from a liberalization with you provinces to the extent that you are willing to liberalize these rules. So the federal government could, there's a world in which the federal government could incent provinces. Of course, provinces will benefit from liberalization through an increase in their own revenues, but you could also, the federal government could say, we're going to take that portion of our revenues that's due to that increase, and you'd have to measure it. I mean, that's, it's easier said than done, and add that to the pot. And federal government could do that, could try and do that in a world. It could try and say, provinces, you're going to have to agree on this, and that's where you get the maximum benefits. But you could also do it by province, and you could be rewarding those provinces that liberalize with the share of the tax revenues that the federal government would collect. Now, those provinces that receive equalization might say, well, that's all very well, but if my tax revenues go up relative to other provinces, then I lose out on equalization. But you could cut them a deal. You could design the equalization system a little differently to allow this to happen. So I think there are some ways for the federal government to move this process along.
Oh, I think Canada's done very well on a number of issues, mainly because federal and provincial governments have been able to cooperate. And I've been around the table, for example, getting CPP reform was not something that was easily done, but it did get done, partly because the federal government could make offers on some other issues to a province that was against CPP reform back in 1997, and was able to get their acceptance of it. So you don't even. So it's sort of like Tim's comment about, it doesn't even have to be spending power. It could be just settling a number of issues at one time. And we've done a great job on our tax system in Canada for a federal state. It's a decentralized tax system compared to many federations. But we've had tax harmonization agreements in sales taxation, corporate taxation, personal income taxation. And it served Canada well. And the federal and the provincial governments have gotten together. At times there are irritants and there's problems that arise. But generally, I think people have recognized that there's some significant benefits to harmonization. And those provinces that didn't want to be part of the harmonized agreement, such as in the case of Quebec and the personal income tax, and Alberta and Quebec in the case of the corporate income tax, it's interesting that by and large they still adopt a lot of the same provisions as the federal base, even though they're not in the harmonized agreement, because it's in their interest to do that. I've argued that we have made a huge mistake in carbon policy in Canada, because we have not taken the same approach for tax harmonization as we could have for carbon. If the federal government sat down with the provinces and come to an agreement on targets or whatever that one would like to have for carbon policy, it could leave to the provinces the way of trying to achieve that. And if they don't achieve it, then of course some sort of way of penalty could be assessed for that. My main point is that you could have a harmonization agreement around carbon policy, just like you have in tax harmonization. Instead, the federal government imposed a carbon tax as a minimum tax and forcing provinces to do some of the things that they didn't necessarily want to do. And I think that was a mistake. In fact, it's not even clear carbon tax is the only policy, given the governments have introduced 247 different carbon policies in this country to solve the issue around carbon. It obviously means that carbon tax is just one out of many different choices being made. So why not let the provinces sort of figure out what's best for them, but come to an agreement with the federal government and other provinces about how to go forward as a country together, and to try to even harmonize some of the policies, because right now that's not even happening in this country.
Very good. Okay, so we've heard lots of ideas, lots of theorizing, which is obviously the important first step. But now let's get practical and talk about those most likely to see success. Some of the proposals obviously require constitutional amendments, which are very difficult. Another issue is the slow and gradual muddying of federal and provincial jurisdiction that we've heard many examples of. It's kind of led to a complicated morass of regulatory complexity and regulatory barriers now in place, which I think it's probably both legislatively complicated as well as politically unpalatable to address in certain ways. So some have floated the idea of a kind of grand bargain needed between the federal government and the provinces to cut through this Gordian knot. Looking at things practically, and I'd like to hear briefly from each of you before we move on to our audience questions, and strategically, what are the most promising paths forward to realizing, one key aspect, let's say, of the economic vision of the Constitution? Not all at once.
Do you want to go?
Oh, you go
Okay,
ahead.
sure. I mean, so a grand bargain might be one mechanism where sort of the provinces get something that they want, perhaps greater autonomy over healthcare. I know this is something the Constitutional Reform Commission in Quebec has recently suggested is something that they would like. At the same time, the federal government might get some things that it wants in terms of removal of trade barriers. I think there's something to that. History suggests we shouldn't be too optimistic about that, just because of that collective action problem of getting all the provinces together and them each having their own special interests. So I wouldn't, I think that there's some promise there. But I would also want to put on the table a couple of more things that I think Parliament could probably do unilaterally, because that's just a little bit easier to get across the line. And this is an aspect of the book that has gotten a little bit more attention than others. There's a few sort of areas of low-hanging fruit. Interprovincial trucking companies are interprovincial undertakings. Parliament could assert jurisdiction there and harmonize it unilaterally, probably. Alcohol, you mentioned that you'd like to order. Was it whiskey or was it something else? Scotch, okay, yeah. There as well, Parliament has jurisdiction over interprovincial trade and could probably legislate a right for personal consumption to order. And then you could have broader measures if you're really getting ambitious. And one of the ideas I float in the book is a federal right to engage in interprovincial trade, subject only to non-discriminatory provincial regulation. This would be a bit more of a stretch under the Trade and Commerce Power, but under existing jurisprudence, I think a case could be made for it. And certainly it would sort of, as you say, cut the Gordian knot or short-circuit some of the problems of political economy that we have when we get all the provinces around the table, say for the Canadian Free Trade Agreement, where you have all these exceptions. So I would just put that sort of more unilateral approach on the table as I had in the book, but I think the grand bargain idea also has some promise to it.
I mean, maybe a little pessimistic about this, but I think what it will really, let's take federal intrusion into what provincial governments do, which the government has been merrily engaging in for more than 9 years now. And of course, there's a longer tradition than that. I mean, my guess is it's going to take a fiscal event to really dial that back. It's what we saw in the early 90s. The federal government is going to be increasingly under pressure to spend money on defense, on border security, on fighting organized crime. The price tags are going to be very significantly high for that. Tax revenues are pretty high as a share of GDP now by historical standards. I don't see them going to that well. So something will have to give, and that something will have to be the things that the federal government doesn't have to do. Because border security, defense, immigration, these are all things that the federal government has to do, and will have to do it in part because the Americans are going to make us do it. And so that will just require the federal government to pull back on a lot of these areas where they've expanded the spending power. And you're not going to be cutting old age security. You're not going to be cutting equalization. It's going to be areas where, like childcare, for instance, where the government's got involved. It's going to be things like pharmacare. Those things that are they are frankly nice to haves from a federal government perspective, but they are not essential to what the federal government does. And I think also at the provincial level, it's going to require, healthcare reform is going to require a province that hits a fiscal barrier and is forced to make changes, and to go to the federal government and say, look, the Canada Health Act is too much a constraint for us. We cannot afford this. And unless you, federal government, are going to bail us out and give us a lot more money, you need to let us change the structure of our healthcare system. So that will not be pleasant for anybody, but I suspect that's what it's going to take to make a major change from where we are now.
Jack?
Well, I think in some ways I'm going to add to what Tim said. first of all, crises always help because that's when you often get change. And the reason you get change is because voters realize that something has to be done. And I think part of the problem with internal trade is, we can talk about these studies that are done about 5% increases in GDP and stuff like that, but people don't feel it. Most of the public have no clue or understand issues around internal trade. And when you start getting to specific issues, the examples, there's the Como case, in New Brunswick, but, how many people are really involved in that sort of thing, and how much are they really affected? It just doesn't have a lot of political ring. And I think that's the reason why internal trade as an issue has had very little development over the years. There has been improvement. In fact, I think we should give ourselves some pat in the back that we have done some reduction in barriers, but it just doesn't capture the minds of the public right now. It is a non-issue to them, and that's because it's been very hard for governments to sell it as a major issue, outside of quoting some study that says 5% increase in GDP, which nobody's going to believe that when they don't even feel it. So it is the crisis that is, I think, that's going to have to lead to significant change in the way that we do things, and even in the case of property, which I totally agree with Malcolm on and what he's saying, but even that one is going to need some sort of instance where people start saying, we really have to protect people's property. It's just not fair. But we need that kind of spark, I think, to get the public to say that a change is going to be required.
Yeah, maybe the threat of external tariffs will raise awareness of all of the internal ones.
Yeah, well, that's what worries me, because the debate over free trade today is not let's have more free trade.
Right.
It's let's have more industrial policy. Let's have more protection of industry.
Yeah.
That's where the world's going right now. And that's why I think internal trade is very difficult to sell.
Yeah, I agree with. I think the fiscal event, just public choice incentives in government, that will be what pushes them to finally do something on it. I am encouraged. I think one thing is to start trying to calibrate public opinion on this, and so I'm encouraged by leader of the opposition's plan to create a Blue Seal Commission for labor mobility in the regulated professions. I think modeling it off the trades, I think that's a valuable first step on an issue where people would notice a difference there, and so I think that's important. On the legal side of things, I think litigation is increasingly important, and there are great organizations that you should support that are putting forward these ideas before the courts regularly. You see the folks from the CCF here. They were on in the Annapolis. That was you, Count. So, the Annapolis case, where there's a valuable contribution to our understanding of property rights, the CCF and Malcolm are there to help shape that, and that makes the difference. There's other organizations that do this as well in other cases. More of that, intervening in these cases, making those principled stands, that's going to be increasingly important. When if you go to the Supreme Court, you'll often see 12 interveners on a big case, all in favor of one thing, and maybe the CCF on the other side of the thing, or the advocates to the rule on the other side of it. And it's a minority position, so that's why we certainly need more of it. Once we start getting this before the courts more, and putting aside the fact that intervention is a tricky business. It's a tricky business for courts to manage. I think we can start to develop the vocabulary, getting back to that common law heritage. And that's why these organizations are so important. So more of that, I think, is going to meaningfully change how we look at this legally.
Excellent. Let's turn to audience questions now. Brian, we've got to definitely give Brian an opportunity.
So let me suggest a way that we might square the circle here, because I completely understand what people on the panel have said, like removing internal barriers to trade gets no political traction, protecting property rights gets no political traction, there's a whole series of other things get no political traction, even though they might be very valuable to Canada if we could get them. But you see, I think no political party is successfully putting them in the context of, I'm here to improve your standard of living. I want you to have more money. I want you to have more income. I want you to have more job opportunities. And all of these things will be accomplished by, here's the menu. And I think about, I always like to hold up the the Australia example, 25 or 30 years ago, they had essentially a royal commission on, how do we get out of the low growth trap and improve productivity, improve the standard of living of Australians. And this brought about policy change across a broad front. They got rid of state-owned electricity utilities, et cetera, et cetera, et cetera. And the result was 25 uninterrupted years of economic growth. No recessions, nothing, while Canada's been through several, to say the least. I think that became politically possible because the politicians were able to connect all of these sub-themes, which we as technicians understand are important to the objective, which is to raise the standard of living for people. But the average person doesn't get the connection between property rights or any of these other things, or even corporate tax rates or whatever it is, and their ability to get a job and see their income go up. So I think we have to turn it the other way around and we say, we're here to lead a conversation about how to make Canadians better off. Because I think if you look at the public opinion polling, what the polls are telling governments is they're pissed off at how their standard of living has not improved. They've seen inflation take away the value of their earnings. They've seen taxes go up. And they want to see this reversed. They say, no, I want to keep more of my money. I want to have more opportunity. I want to see my wages go up. And a politician who said, I'm here to make that happen for you, and here's the menu of things we have to do to make it happen. I think that's how we do it.
That's great. So the political sell to the success of this issue. Let's take another question, and then we can. Oh, I see one behind you there, Jacqueline.
Well, my question was, what do you think?
Okay. Well, first, thanks to the panel for the really great conversation. So I had a question about a different section of the Constitution. So 121 came up quite a bit, but in Section 91, the federal government is, it has responsibility for regulation of trade and commerce. And Malcolm, you mentioned that in your closing remarks. And other federations have similar clauses. The United States, Australia even as well, as Brian mentioned that, where it's interpreted more broadly than it is in Canada. So I guess for Mark and Malcolm, what is it that led Canada to interpret that power so narrowly? And what did the original framers of the Constitution interpret those words to mean?
Great, let's start with that. And then
Great question. I'll have to stop myself from saying too much on this. So that's a great question. And part of how we got to a more limited understanding of the trade and commerce power, which I think is actually correct. I don't think the trade and commerce power should be interpreted as broadly as the U.S. Commerce Clause, which allows the federal government to do almost anything. It's a case called Parsons, and there was a recognition, looking at the text of the Constitution and the context and purpose of its enactment, that you have to read trade and commerce in concert with the provincial power over property and civil rights. That if you interpret trade and commerce too broadly, it devours property and civil rights. And that an important purpose of this Constitution was to give an important domain to both the feds and the provinces on economic relations. And property and civil rights was interpreted to be quite broad and quite important to be under provincial jurisdiction. And so the interpretation that they gave said, well, we can't look just to the ordinary meaning of these words. We have to read it in concert with the other provisions. And so that means focusing on interprovincial and international trade, and then a narrower branch later recognized called the general branch of the trade and commerce power, which generally deals with things that can't be effectively done locally, such as competition policy, that kind of thing. Relatively narrow, though, in terms of trademarks are another one that have been recognized under the general branch of the trade and commerce, but relatively narrow. And the reason for that is the need to read it together with the property and civil rights power. And I actually think that's correct, but we shouldn't give an unduly narrow interpretation to the interprovincial branch. But at the same time, we need to be careful about those principles of subsidiarity and local autonomy.
The only thing I'd add, and this is just maybe a harebrained theory, is that up until the middle of the century, the 20th century, all of these cases that correctly, I think, read the trade and commerce power against the property and civil rights power were decided by the Judicial Committee of the Privy Council in England. And there is a distance there that probably didn't exist in the United States when the United States Supreme Court was asked to broadly construe the trade and commerce power. There was an understanding among the judges on the Judicial Committee of the Privy Council that this was a compromise that was set up in a federation. And good legal method leads us to the conclusion that these two things have to exist together. And so I wonder, there may be an institutional explanation for why that's the case.
The first question, if this is sold and connected to standards of living, can you get more traction politically?
I mean, you know, with these things, you kind of have to catch a wave, right? And there's moments that come, and if you're ready to catch that wave with not just one policy here, one policy there, but with a policy suite. Often early on in the mandate of government, there's pain, you get it over with early, and enough time elapses that you can then show the populace that the economy has improved. And I think that's what you saw in Australia. I mean, it's what you saw in Britain in the 1980s, for instance. Trying to do this piecemeal is really hard. The hardest thing in politics is to hurt a small number of people a lot in order to benefit a very large group of people a very little bit. Right? That is not how the political system is supposed to operate. But if you can try and if you can hurt an awful lot of people a little to help the great mass of population quite a bit, then you're in business. And I think as well the Australians, they set up this productivity commission, which continues to did good work for a long time. I mean, they tried to take it a little bit outside the realm of politics. I don't know how easy that would be in Canada. So I don't think that there's no hope. I do agree. I mean, our productivity hasn't grown for 6 or 7 years now. I think people are aware of the growing gap in the standard of living between ourselves and the United States. There's one thing as well when you observe the political world is absolutes don't matter. Relatives matter. Relatives matter a lot. Relative to recent experience and relative to people that you can see just on the other side of the border. And certainly, we are certainly in a situation now where people have, and I'd say relative to experience, so people have standard of living have kind of sort of gone up for a generation, and now they've done that. And we look at the Americans, and they're doing this. So, I think this is probably as good a time as any.
Yeah, I would agree actually with what Tim said, and just put a slightly different aspect to it. There's no question, I think now we have a different temper what's going on in the country. People are not been able to keep up with prices in terms of their incomes. Per capita household income actually on an inflation-adjusted basis has been falling. It's not just GDP per capita has been falling, but actually household income per capita has been falling. And of course, voters are voting against governments who are not dealing with so-called affordability. Unfortunately, affordability as a topic are not doing what you would like to see being done, Brian. It's talking about, let's have a GST tax holiday, or let's have a fuel tax holiday. None of this is going to help grow the economy. By the way, that's my article this week. But anyway, but instead, what we're doing is we're picking a bunch of Band-Aid solutions to say, okay, we're going to lower prices this way, and everybody is going to have a more affordable existence. Instead of saying, why don't we grow the economy so we could put more money into the hands of people? That's, I think, going to be the bigger question. And of course, what are the major things that we need to do that? And I think that's going to be, and it may be a whole bunch of things. Internal trade is one of them, not the only one. And there may be a whole agenda of things, but I think we may be getting to a point where, and I hear this in Toronto all the time in the business community, people are now starting to say, we need to get something done. And they are going to be looking for solutions. And of course, at times we've been able to do it. Like when I did the tax report from Paul Martin years ago, at first, people didn't want to do anything, but they realized that we needed to do something on globalization and competition, and something had to get done. And we did do something. So, I'm optimistic it's going to happen over the next several years, but I think defining the agenda so that people really feel this is what needs to be done, I think is what's going to be critical.
Jack, it's 7:35. I know you've got to run. Do we have time for one or two more?
Yeah.
Okay. Jack, any more questions?
I got my boarding pass. So it's
okay, right here.
Yes, I'll try to be brief. My name is Bob Haig. I a little anecdote. When I was with the Foreign Service, I was introduced by our ambassador to Pierre Trudeau. And he asked me, he said, "Where are you from, Bob?" And I said, "I'm from Calgary, sir." And he said, "I'm sorry I asked." Now, little did he think that his son would say the same thing. So I'm wondering again, Malcolm, about this interprovincial trade. Apparently we lose billions on this. That's what I read on statistics because of the failure of...
Some guy named Trevor Toome might have said
maybe.
that.
And so to have a case where a worker with beer in his trunk is determined by the Supreme Court of Canada as a signal to where we're going on that. Isn't that a bit bizarre?
Yes, it was a very interesting and very unusual case. But it was a case that, with a sympathetic litigant that brought the issue before the Supreme Court. There was actually some broadening of the ambit of Section 121 that came out of that litigation, not as far as many people would have liked. Yeah, it is a strange issue, a strange way in which that case ended up going to the Supreme Court of Canada, effectively directly from the New Brunswick Provincial Court, by the way. The Court of Appeal denied leave. It's a very, very unusual case, which sparked my interest in it. In terms of just some of the broader issues we've been talking about, I would just add that to the discussion that ideas actually matter quite a bit. And that's why the work of something like the Macdonald-Laurier Institute is so important in linking in. Yes, and thanks for dinner. Just in linking, when people think I'm really unhappy with my standard of living, link that to the idea that, well, we could be doing a lot better on interprovincial trade. There are ways in which we can be enhancing our wealth. And within, say the legal community, I talk about some sort of niche legal ideas in this book. Organizations like the Canadian Constitution Foundation and the Runnymede Society, which Mark Mancini led, sort of broadening the base of ideas out there. There's no inevitability to the idea of flexible federalism or to the idea that property rights aren't real rights. When you have these types of discussions, you can broaden that, and the ideas ultimately can matter. So, thank you.
Last question.
My name is Mark Nadeau. I'm a former judge, so I guess I'll ask a few questions about the law. But I wanted to say, because I read Jack Mintz every week, and I think he's a great writer and thinker, and I'm actually happy to have the chance through the Institute to actually see him and meet him, and hopefully I'll be able to say something to him before I go, before he goes. Mark, I'd like to ask you, you talked about the common law and rights. The Americans have a theory called the theory of natural law, which was discussed by the founding founders in 1776, and it implies that when Americans entered the Constitution, they had property rights which could not be touched by the federal government or the state governments. Do we have anything similar to that? You talked about the common law rights, but could we argue that we entered into this Constitution and the Charter with these rights that we had before we actually began talking about rights?
Well, there's a tradition of arguing this, as you know, Justice Nadon, in English history. Writ of habeas corpus was seen as something by some thinkers that Parliament couldn't touch. That was a protected constitutional right beyond the reach of Parliament. The Charter was supposed to be our chance to put that down on paper. And it was perhaps well-intentioned, but the problem becomes when we turn the interpretation over to the judiciary. There are incentives there. There's results-oriented reasoning. There's worried about consequences like in Como. I think a worry was that if we strike down these trade barriers, that's it for the administrative state. And we don't want to go there. And that's the challenge with the written Bill of Rights that we have now. So part of it's going to take a correction on that course, and that's where the litigation comes in and the thinkers come in and it comes in. But I also think that we just need a better understanding of what Parliament was designed to do, because there is this understanding, as I mentioned, that Parliament was going to be presumed not to abridge the rights of the individual. And some of that is now gone. We've lost some of that. Part of it is because Parliament has become supreme, and so with the language of parliamentary supremacy, we lose some of this focus on individual rights. But the two don't need to be contradictory. And so that's where, so we may not have the same, natural rights penumbra that the US has, but we have something built into our parliamentary institutions that is supposed to be doing something quite similar. And we have a Bill of Rights that has gone off the rails, but that we can bring back on. It's not inevitable that it has to go down that direction. So maybe we get to the same place via different routes.
I'll just add very briefly, I completely agree with the congruity between the natural rights tradition and natural law and common law rights like the right to property. I think that's there and that's been recognized by the courts, and we hope to have that continue to be recognized. I would also point out that as I say, there's something enduring about some of the principles reflected in our constitutional text. I refer to this idea of enduring principles of political economy. There's a wisdom here to this structure that is timeless. It's not something that was just true in 1867. It's true today of our contemporary political communities.
Very good. Thank you so much. A very multifaceted discussion, and I think a timely one, as we're going to have an election sometime soon. And as was pointed out, I think economic issues are front and center. So hopefully these issues can be brought to the attention of the populace before the election. So thank you to our panelists and for all of you for coming.